generously supported by Dr. John Schneider, who's also with us today, celebrates the wonderful career of Professor Emerita Ronna Schneider. Ronna was, as some of you know, the second ever tenured female faculty member at UC Law, as well, I'm told, as the first mother on the faculty. She taught here for 42 years, enriching the educational lives of thousands of future lawyers and leaders, many of whom have joined us today. Ronna is known not only as a fantastic teacher, but as an influential scholar, particularly in the area of constitutional law with a focus on the First Amendment and in education law. Ronna is known in the field for her 2-volume legal treatise, Education Law, First Amendment Due Process, and Discrimination Litigation. That treatise continues to be updated annually and addresses some of today's most challenging legal topics, including religion, free speech, due process, gender, and race discrimination. Respect for Ronna's work also led her to being elected as a member of the prestigious American Law Institute. Those are the folks, as the students in the room will certainly appreciate, the folks who write and publish the various restatements of the law. So it is my very great honor, and please join me in welcoming Ronna to the podium so she can introduce our distinguished guest for today.
Well, thank you, Tim, for those kind introductory remarks, and thank you all for coming today. My husband, Dr. John Schneider, created this lecture series when I retired in order to bring to the College of Law important thought leaders in areas that are at the epicenter of many of our... Now, can you hear me better now? Can you hear me? Okay. All right. It's worth hearing me, you know. All right. My husband, Dr. John Schneider, created this lecture series when I retired in order to bring to the College of Law important thought leaders in areas that are the epicenter of many of our national legal debates. More specifically, those that involve two critically important areas that affect all of us, the Constitution and education. Today's lecture on religion in public schools, Constitutional Revolution in Action, is presented by Professor Noah Feldman, who holds the Felix Frankfurter Chair at Harvard Law School. He's also the chairman of the Society of Fellows at Harvard University and the founding director of the Program for Jewish and Israeli Law at Harvard. Professor Feldman is a renowned scholar in many areas and an extraordinary public intellectual. Most amazing to me, I have to say, though, according to Harvard Magazine, Professor Feldman is fluent in English, Hebrew, Arabic, and French. And he also speaks or reads, to some extent, 6 other languages. But don't worry, you'll be happy to know that he will deliver today's lecture in English. Professor Feldman earned his A.B. summa cum laude from Harvard. After Harvard, he earned a doctorate from Oxford, where he was a Rhodes Scholar. He then went to Yale Law School, where he's a book reviews editor of the Yale Law Journal. After law school, he clerked for Chief Judge Harry T. Edwards of the U.S. Court of Appeals for the D.C. Circuit, and then for Justice David Souter of the U.S. Supreme Court. Professor Feldman has written 10 books. In addition, he's also written 2 widely used constitutional law case books. Nearly half of all of his books are on constitutional topics, including one on James Madison, who was one of the major authors of the Constitution, and a book on the complex constitutional areas of church and state in a society of different religious beliefs. In addition to American law, he's also written multiple books on Arab and Islamic politics and culture. In 2003, he served as an advisor and helped draft the Iraqi interim constitution. Professor Feldman is a policy and public affairs columnist for Bloomberg Opinion and is a contributing writer for the New York Review of Books. He was a writer for the New York Times Magazine for many years as well. He has also written opinion pieces in various other publications, including, but certainly not limited to, The Washington Post and Time Magazine. He hosts his own podcast entitled Deep Background, in which he explores the historical, scientific, legal, and cultural context behind the biggest stories in the news. Professor Feldman is a fellow of the American Academy of Arts and Sciences. It's now my honor and pleasure to introduce to you all Professor Noah Feldman.
You're on. Thank you so much, Professor Schneider, Dr. Schneider. Thank you, Dean Armstrong, and thanks to all of you for spending your lunch hour with me today. I'm genuinely grateful for that. I'm going to talk about some late-breaking, brand-new cases that are in the process of transforming the constitutional law of religion in public schools. I'm going to focus on a pair of cases from 2022, so really hot off the presses, that are part of a contemporary conservative constitutional revolution that's happening at the Supreme Court. But with your permission, let me start by providing just a little bit of background context for that. And for that, I want to take you back to the year 1869. And I'm apologizing in advance for taking you back 150 years, but maybe it'll make it a little more engaging by the fact that I want to take you back to Cincinnati in 1869. So in 1869, Cincinnati became ground zero for what turned into, over the next decade, a huge national controversy about the role of religion in public schools. The particular context had to do with the way that Catholics in Cincinnati in particular, but really Catholics all over the United States, felt about the way religion existed in the public schools of the time. Now, the background here is that when Catholics first came to the United States in large numbers, the first really, really big influx came during the Great Famine in Ireland in the 1830s and 40s. But from the minute the Catholics started coming to the United States in large numbers, they encountered public schools in which nominally the schools were secular, but in fact, the schools were non-denominationally Protestant, in the sense that it was standard in essentially every public school in the United States to start the day with a generic but still identifiably Protestant prayer, usually the Lord's Prayer in its Protestant version, and with Bible reading, where the verses were always taken from the King James Version of the Bible, which today may sound kind of beautiful and archaic and non-controversial, but at the time, everyone understood that the King James Version of the Bible was a translation made in England by Protestants as part of the Counter-Reformation process, well, as a part of the Reformation side of the part that Catholicism responded to through the Counter-Reformation. And in case you were unsure about that, there was a long introduction that used to be printed with your King James Version of the Bible. You can find it online today, but you won't find it in too many actual Bibles, that referred to the Pope as, quote, that man of sin. So this is to give you context. So from the standpoint of Protestants, the whole point of this non-denominational Protestantism in the schools was to be as inclusive as possible. Because the idea was, we're not going to teach any substantive theology because we all differ and disagree about that. But at the same time, Americans in the 19th century believed that schools had to teach morality. And they also believed that morality was found in the Bible. And so they thought that a prayer followed by Bible reading was a good way to set the moral tone. When Catholics arrived, they gently pointed out to Protestants, gently because they were a minority, that this was in fact not truly non-denominational. It was in fact exclusionary and Protestant, And the people who were excluded by it were them. And Catholics sought two different kinds of remedies. And these remedies are going to turn out to be directly relevant to these 2022 cases. So I promise I'm getting to the present soon. The first remedy was, okay, can we have separate Catholic schools that will be paid for by our property taxes the same way that the public schools are being supported by our property taxes? Because we won't be comfortable sending our kids to schools where this de facto Protestantism is part of the curriculum. And to that, with about 99% accuracy, I can say that across the entire country of the United States, the response of Protestants was, no, you can't have that. So then Catholics said, okay, well, we'll try to create our own Catholic school system, but that's going to be expensive for us because we still have to pay effectively tuition to the non-denominational Protestant schools as part of our property taxes. So in that case, we would like you to remove from the schools the non-denominational prayer, which actually excludes us, and the Bible reading, which actually excludes us. And in almost every place in the entirety of the United States, the answer from Protestants was, you can probably guess, tough. No, you can't have that. We're not going to allow that. We're not going to permit that. Cincinnati was the exception. And Cincinnati was the exception because of the existence of a large, empowered, and by 1869, wealthy Catholic community, as well as a Protestant community, some of it also German-speaking, that understood that the tensions between Catholics and Protestants that existed in the United States were carryovers from European tensions. And in Germany, by the middle of the 19th century, after 200 years of wars of religion, people had begun to figure out that mutual tolerance was maybe the best solution to this problem. So in 1869, the Cincinnati School Board voted to remove Bible reading and school prayer from the Cincinnati public schools, which was seen in retrospect, I think it's fair to say, an extremely progressive thing for them to do. It was not perhaps exactly what the Catholic community would have preferred. They might have preferred funding for Catholic schooling, but short of that, this was the step that they really wanted. And it was intensely controversial immediately. And it was brought to the state Supreme Court, and it took 3 years for the case to go all the way up to the state Supreme Court. And in 1872, in a case called Board of Education against Minor, the Ohio Supreme Court upheld the decision by the Cincinnati School Board, and a fascinating decision that is, seen through our eyes, both progressive and also a little bit shocking. The progressive part is that the court cited Madison to stand for the proposition that religion and the state were two different domains and should be therefore maintained as separate. In an even more progressive component, the court quoted the Buddha, and I'm going to read you the passage, because this is, to my knowledge, the first instance of citation of the Buddha anywhere in a US case. Quote, quoting Buddha, "Let a man overcome anger by love, evil by good, the greedy by liberality, and the slanderer by a true and upright life." It's a good quote. What it has to do with the subject is a little unclear to me, but it's a lovely quote. And the reason that the court was invoking the Buddha was to suggest that what we don't want is controversy. What we do want is for people to get along. And so by emphasizing love and nonviolence, the court was trying to say, let's avoid a big political fight coming out of this decision. That did not happen. Instead, what happened is that Republican Protestant politicians in the state of Ohio introduced a state constitutional amendment that would prohibit any state funding to quote unquote sectarian, which meant Catholic institutions, which was an interesting state constitutional amendment to introduce because there was no state funding going to sectarian institutions. It was a totally political wedge issue. And they used it in the 1872 election, and it helped get Rutherford B. Hayes elected governor of the state. And it worked because it put Democratic politicians in a funny position. If they voted at the time, here and in most of the country, most Catholics voted Democrat, and many, though not all, Protestants voted Republican. So Protestant Republican politicians could support the amendment, but if you were a Protestant Democrat politician, if you supported this amendment, you would alienate your Catholic voters. But if you opposed the amendment, you would alienate your Protestant voters. And that was the whole point of the proposed amendment. And it worked really well, and the Republicans were swept into office. And then the Republican Party nationally decided to do the same thing at the national level. And it proposed a national constitutional amendment called the Blaine Amendment, which was going to go into the federal constitution, which would say that no state could provide any support for sectarian, that is, Catholic institutions. No one thought it would pass, and indeed it didn't pass at the national level, but everyone knew it would make it much harder for Democratic politicians. And indeed, it was part of the national movement that led to not the direct elections, since that's not how he became president, but the election of Rutherford B. Hayes ultimately as president of the United States. And just parenthetically, just because it brings me and you together, he was the first person ever to go to Harvard Law School to become president of the United States. The second was Barack Obama, so that's a long run in between. One is a little more famous today than the other, and I think possibly with good reason. But Rutherford B. Hayes was also a Cincinnati politician who took this controversy in Cincinnati nationally and wrote it all the way to the presidency. Okay, so why did I start with this background? I'll tell you why. It's because the two core issues in church and state in schools in the United States have been for 150 years the same two issues. Number one, can the government support Catholic schooling? And of course, other forms of religious schooling can fit into that category as well, Jewish and Muslim and so forth. But statistically then and now, the largest system or program of religious schools in the United States is Catholic. So it began as an issue primarily focused on Catholic schools, and it remains that. And sure enough, that's the first issue I'm going to talk about. I'm going to talk about the current state of the law and the current changing state of the law with respect to state support for religious education, Catholic education. And that's a 150-year-old issue that goes right here to Cincinnati. The second major constitutional issue, then and now, which also takes you back to 1869 in Cincinnati, has to do with religious practices like prayer and Bible reading in the public schools, which was the issue that the Cincinnati School Board voted on. That issue as well is undergoing a revolution in constitutional law, going right up to these two cases I'm going to describe in 2022. Okay, so I hope I've set the stage clearly here. On the one hand, we've got the question of government funding of religious schools. On the other hand, we have the question of prayer in the public schools. Those have always been in the United States, and they still are today, the two primary constitutional questions. Not the only ones, but the two dominating constitutional questions in this field. And each is undergoing a revolution. So let me turn to that actual revolution by talking to you about these new cases, what they say. And then after I describe those two, I'll come back to the question of where we're going in the future and how we should feel about those two cases and the current revolution. So let's start with state funding for religious education. the first significant development going all the way back to the 1840s and going all the way forward to the present in this area took place in the early 2000s when the Supreme Court held for the first time in a 5-4 decision that if a school district wanted to allow a voucher program that parents could use to send their kids to religious schools, in practice Catholic schools, that doing so did not violate the Establishment Clause, did not violate the separation of church and state. That was a big breakthrough moment. I was a baby professor. I was very focused on this issue. Ronna mentioned that I wrote a book about constitutional church and state issues, and the whole section about it is about the school wars then and what was the case then and what was then now, so almost 20 years ago. And like a lot of people, I thought that this was a remarkable, shocking inflection point, because until then in US constitutional history, the consensus had always been that if your taxes are gathered by the government cannot then take those taxes and spend the money that comes from you on religious education. And the vouchers program, seen from one perspective, did exactly that. It took tax dollars and redistributed them for religious education. The majority of the Supreme Court, though, that held that this was constitutional, saw it differently. They said, this is a voucher program, so therefore, the government's not really paying for religious schooling. The government's providing a general good, education, and through this vouchers program, it's letting you use that as a parent on whatever education you want your kids to get. And so the intermediating factor of parental choice, which is what works in a vouchers program, means that there's no violation of the Establishment Clause and no violation of the separation of church and state. Now, after the Supreme Court reached that decision, lots of people, myself as a baby professor included, thought this was going to open the floodgates for lots and lots of vouchers programs to be created all over the country to support religious schooling. And this was the first of what would turn out to be many mistakes that I made in my academic career. I thought this was a real possibility, even a likelihood, and it never happened. Now, why didn't it happen? The reasons are complicated, but at their core is actually a really interesting and important reason. Namely that most people in most places in the United States didn't actually want their tax dollars to go and support religious schools of religions they didn't belong to. Now, some of that is good. We think that our tax dollars, as a matter of conscience, shouldn't support lots of views we don't like. I think that's fine. Some of it was a little less attractive. Some of it was Islamophobia, concerns among people who might really like to send their kids to Christian schools, that they really didn't want their tax dollars paying for Muslim schools. So, one can have different views about the morality of why that didn't happen. But ultimately, it didn't happen because we're a very diverse country when it comes to religion. And in most places in the country, people were pretty satisfied with their public schools and did not enact something they could have done constitutionally, namely vouchers programs to fund religious schooling. Now, fast forward to 2022. The revolution of 2022 with respect to government funding of religious schools comes from a very brilliant argument made by advocates of religious schooling that deploys a strange feature of the constitutional relationship between the two clauses that govern church and state. The Establishment Clause, which I've mentioned, which says that Congress can't establish a religion, and the Free Exercise Clause, which says that the government cannot interfere with the free exercise of religion. So advocates for religious schooling began to argue in court very brilliantly, and as you'll see in a second, I say it's brilliant because it's so counterintuitive, that It's not just that the Establishment Clause allows school vouchers. It's that when a school system provides money for education generally, it must provide funding for religious education as well, because if it does not, then it is discriminating against religion. Everyone catch that? Because it went a little fast. I'll give you the concrete case. Case came out of Maine, and Maine is a very rural state, as you know. And so lots and lots of cities and towns in Maine don't have their own high schools. They might have an elementary school, maybe a middle school, but they don't have their own high school. The high schools are more regionalized. And sometimes Maine being a very, as I said, a very rural state, sometimes people have to travel, kids have to travel a pretty long distance, sometimes taking a ferry to the mainland, various other things they have to do to get to school. So Maine created a law that they've had on the books forever that says that if you're in one of those towns where there's no high school, the state will pay, which really means that the town has to pay, for your kids to go to school wherever they want. They can go to the local public high school, or they can go to a private high school, and the state would pay for that. But the state did not allow you to take that money and use it to go to a religious school. And so the challenger said, that's discrimination against religion. You can send your kids to the private school, but you can't send them to the religious private school. That violates the free exercise of religion because it discriminates against religion. Now, you can guess probably what the state said in response. The state said, well, we're not discriminating against religion. The Constitution's discriminating against religion, because the Establishment Clause is the part of the Constitution that says the government can't fund religion, can't fund religious schools. But the Supreme Court, in a case called Carson against Macon in 2022, said, no, it is religious discrimination in violation of the Free Exercise Clause for a state to fund people going to private schools, but say they can't go to religious schools. Now, that is a first in US constitutional history, and it is genuinely revolutionary. Why is it revolutionary? It's no longer saying, well, if states want to, they can fund religious schools. It's saying if they fund non-religious schools, private ones in this instance, they must fund religious schools. It's mandatory that they do so. And you can imagine what the most likely next step will be from the standpoint of the advocates of the government funding of religious schooling. It will be to argue, they haven't done this yet, that because the government funds the public schools, and because the government funds charter schools, it must fund religious charter schools and perhaps all religious schools. Now, if the court gets to that next step, and I would say that doctrinally on the question of charter schools, they're sort of already there. Notice where we would be relative to where Catholics wanted the United States to go all the way back in the 19th century. We'd be in a place where it was constitutionally obligatory for the government to fund the Catholic school system, provided it has public schools at all. That would be an extraordinary instance of constitutional revolution in which a conservative Supreme Court would engage in an activist interpretation of religious liberty under the Free Exercise Clause to essentially flip on its head the old constitutional law model going back to the 19th century, in which the Establishment Clause says that the government cannot fund religious schooling. So we go from the Constitution says you can't fund religious schools to the Constitution says you must fund religious schools. That is a genuine constitutional revolution. Now, as I said, we're not all the way there yet, but if someone brought a case tomorrow involving religiously oriented charter schools, I think the Carson v. Macon logic would already control the outcome of that case. Because the Supreme Court has already said that there are some circumstances where it's mandatory for the government to pay religious school tuition. So that's revolution one. But I'm not done. I said that there's also a body of law governing prayer in the schools. Now, that body of law in the modern constitutional era goes back to the 1950s and 60s, when the Supreme Court formally struck down school prayer and Bible reading in the schools. It was very controversial through the 60s and even into the early 70s, because lots of people all over the country were accustomed to prayer in the schools and were really upset that it was taken away. I should add, when I teach this material to my students, I always ask, is there anyone who either grew up in a town or has taught as a high school teacher in a town where they still have school prayer in the public schools 50 years after or 60 years after the Supreme Court ruled it was unconstitutional? So I'll ask it now. I'll ask the same question here. Anyone grow up in a place where you actually had prayer in your public school? 1, 2, 3. Yeah, so it still exists. Still exists. Mind saying what states you grew up in? Yep, that's one. That's a regular one. Texas, oh, that's interesting. Yeah, I get West Virginia, Texas, Tennessee. And the reason that that still exists is not that it's constitutional in those states. It isn't. It's, do you want to be the one person in the town who calls the ACLU and brings them in to litigate, to tell everybody in the town that they can't pray in school anymore? Usually that would be a poor choice if you wanted to, I don't know, live in the town. So it's an interesting case because it just shows you that our Constitution is not the same on the ground as it is in the law books. And I can't think of a more useful message for law students than to always remember that there's the law in the books that, Professor Schneider and I teach you, and then there's what actually happens, and they're not always the same thing. You need litigants, you need institutions to make the argument, you need someone willing to stand up for it, you need to keep an eye on it. I mean, those are not one and the same thing. Okay, but at least in theory, the old-fashioned kind of mandatory morning-based school prayer, and the court did not only restrict it to mandatory, it includes optional school prayer, that's also supposed to be unconstitutional, has been banned. That has been changing. And also in 2022, in a case called Kennedy against Bremerton, the Supreme Court held, under the following facts, that a limited form of prayer is permissible in the schools. And I'm going to describe the facts to you, but they're not really where the revolution lies. The revolution is going to lie in the doctrine, which I'm going to get to in just a moment. So the facts were, high school football coach, team gathers at the 50-yard line to pray before and after the game. Coach leads the prayer. Coach says, it's an optional prayer. You don't have to participate. Now, how many people here participated in high school sports? Now, I don't know about you guys, but the coach of my high school basketball team was by far the most important human being in my life in high school. It's not that, my parents didn't love me more than the coach did. My parents definitely loved me more than the coach did. It's that the coach controlled my playing time. And that was the most important thing in my entire existence. Even in retrospect, when I talk about it, I can feel it. And I'm old. So for those of you for whom high school sports were a formative life experience, I've got this news for you. It was, and it's going to be. You're never going to forget those experiences, the good ones or the bad ones. So the plaintiffs in the case said, well, actually, in this case, I stated a little bit wrong. The school board kept telling the coach, don't do this. And the coach kept doing it. And so eventually the school board sanctioned the coach. So then the coach went to court to say, I have a free exercise right to pray, provided I'm not the government when I'm doing it. And the Supreme Court held, you know what? The coach is not the government. He's a teacher like the other teachers. He's paid by the school. It's an official school activity. But they said he's not really doing it on the school's time. And he's not doing it in his capacity as the head coach. He just happens to be the head coach. And the kids on the team who are praying are free not to pray. And the possibility that they might feel that they didn't have a whole heck of a lot of choice if they wanted to be on the coach's good side, but to participate in the prayer, the court dismissed as insufficient to count as coercive under the Establishment Clause. Now, we could have a factual dispute about how much power your high school coach has over you and whether you feel coerced by the things your coach tells you. And that might differ from person to person. There might be some people who've got such strong characters, they're just fine standing up to the coach. Or, maybe they know they're not going to get playing time anyway. But here's the key point. In the course of reaching this holding, the Supreme Court, in this decision written by Justice Gorsuch, held that all of the tests that the Supreme Court has been using to apply the Establishment Clause since 1970, 71, are all overturned. So there were two major tests. One was called the Lemon test, and it required government action, if it was going to be constitutional, to have a secular purpose and secular effects, and not to entangle the state with religion. And the court had never overturned that, even though it's been an unpopular test for many years. The court always would say, well, we haven't used this in a while, but it's still on the books. The court has now struck down the Lemon test completely. And the court also struck down another test that goes back to the mid-1980s that was invented by Justice Sandra Day O'Connor, called the endorsement test. The endorsement test was a tweak of the Lemon test. And what it said was that the government violates the Constitution if by its actions it endorses religion by sending a message to some people that they are insiders, favored members of the political community because of their religion, and a corresponding message to others that they are outsiders, disfavored members of the political community based on religion. Now, under the endorsement test, it would have been tricky to say that the coach in Kennedy against Bremerton wasn't endorsing religion. Not impossible, but tricky to say. But instead of just applying the endorsement test and concluding there was no endorsement of religion, the court said, we're done with the endorsement test. So what's the test now, you may ask, as indeed my students ask before the exam every year. Well, the court spent one sentence on that. It said, we now look to history and tradition to ascertain the meaning of the Establishment Clause. Now, this will also show you why it took us back to 1869. Our history is long on the question of church and state in the schools, and our history is very, very complicated. It's very complicated because it involves both things we could be proud of, like the Cincinnati School Board taking Bible reading and prayer out of the schools in order to accommodate Catholics, and then lots of stuff that we cannot be proud of, such as the statewide and then subsequently national campaign to ban government funding to religious schools, which already didn't exist, in order to send a message to Catholics that they were excluded from full membership in the political community. So how do you apply, if you're a court, a history and tradition test when the history and the tradition run in such contradictory directions? In the gun context, where the court has also, around the same exact time, in fact, it was the same term, adopted a history and tradition test, right now we have no idea what that means. Because it turns out that when it comes to guns as well, our history and tradition is very complicated. We do know that in the church and state context, when the court applies history and tradition, it often looks at things it doesn't like the Blaine Amendment that I mentioned to you earlier, and says, we're not going to count those in our history and tradition because they were bad. We know this because the court said this in Carson against Macon, the main free exercise case that I mentioned, where it had to confront the reality that it was about to hold that the free exercise clause required the funding of religion, when the entire history and tradition of the United States is against the state funding of religious education. And the court said, well, that's because of the Blaine Amendment, And the blame amendment is bad, so we're not going to include that in our history and our tradition. So now what we have is history and tradition that we like. Okay, that's what the history and tradition test is explicitly, not implicitly. This is all on the surface. Court's saying flat out, history and tradition, but we get to, as they say, pick our friends. So now, if you have a case before you, or that you're litigating, involving the question of prayer in the schools, what's the law? No one knows. No one knows. I just read an interesting law review article that the person who wrote sent to me, arguing that even under the history and tradition test, you still can't have school prayer because those cases are about avoiding the coercion of people who don't want to pray into praying. And we have a history and tradition of prohibiting coercion on religious matters. And I haven't yet written back to this impressive young professor full of vim and vigor. But when I do, I'm going to say that's a really nice theory, but it's got two problems. One, most places that would like to have prayer in schools would say that it's not coercive, because they'd say if you don't want to pray in class, don't pray. And the Supreme Court has historically ruled that if you're in a middle school or a lower school and everyone else is praying, you're going to feel coerced. But you're not literally coerced. And so the Supreme Court could say that the history and tradition is of literal coercion. And then if you ask me, well, on what grounds are you going to say this to this nice young person? The answer is Kennedy against Bremerton, where the court held precisely that the players on the football team were not being coerced because they weren't in any formal trouble if they didn't pray. So even the doctrinal holdings that say no prayer in the public schools are now deeply in question. Deeply in question. And if someone came to me from one of your towns in West Virginia or Texas and said, okay, we want to litigate, and can we win? I'd have to say, I'm not so sure we're going to win this one. And I'm not even so sure we should bring this case, because if we bring it, what we might get is a Supreme Court holding that says, provided no one is expelled from school for not praying, there's no coercion. And so therefore, consistent with our history and tradition, prayer in the public schools is entirely permissible, thereby reversing about 60 years of precedent. Okay, so now you've seen what this revolution looks like. On the one hand, Supreme Court holding that the Free Exercise Clause mandates state funding for religious education in some contexts. On the other, a Supreme Court decision vitiating the core principle of no prayer in the public schools on the grounds that it would be coercive. So now, let me conclude by asking the famous question, what's going to happen next? And I should begin by saying that, as I mentioned to you earlier, I'm no better at that than anybody else. And I know that because early in my career, I was convinced that after the Supreme Court's vouchers decision, we'd get lots of school vouchers programs all over the country. It didn't happen. So I learned from that a good lesson for a law professor, which is probably a good lesson for anybody, which is don't go around prophesying, because you don't know exactly how complicated things are going to play out in real life. On the other hand, you also can't do your job as a lawyer if you don't advise clients about the probable consequences of a development in the law, because that's why they're paying you. They want to know what's more likely than not going to happen, so you have to make a crack at it. So let me make a crack at it. We're at a transformational moment in the history of the Supreme Court and constitutional doctrine on a wide range of issues. A wide range of issues. Dobbs and the overturning of Roe v. Wade is the most prominent in the moment. But in the last few years, the court has also engaged in revolutionary decisions on guns, which I mentioned, on affirmative action, which I haven't mentioned, but which you all know about, and in this instance, in both the Establishment Clause and the Free Exercise Clause, so both sides of church and state. And other things are going to happen this term, too. I'm not sure Chevron is going to be overturned, but for those of you who love ad law, and this is a room full of lawyers, there must be someone who loves ad law. What's going to come out on the other side, even if Chevron isn't overturned, is some substantial weakening of Chevron doctrine, some remaking of Chevron, so it means something different than what it meant when you took ad law this past year. You know, if you're taking ad law right now, how many people are taking ad law this semester? Oh, almost nobody. There you go. Well, lucky you. I was going to say, when your exam comes, it's before the Supreme Court will have decided the case, so you're safe. But this is the last semester that you're safe. Next semester, ad law is going to look different. So we're in a revolutionary moment. Some of these revolutionary decisions lead to immediate transformational real-world change. That's already happening with Dobbs, and it's all over the newspaper. So since it's not my topic today, I'm not going to talk about it. Others lead to a more gradual developmental shift in the real world. That's what will happen in administrative law. It'll be a slower, more gradual transformational shift. So the question is, will Carson against Macon and Kennedy against Bremerton, these two 2022 cases, be the kinds of cases that lead to overnight transformation or a more gradual revolutionary transformation? I think the answer is likely to be the latter. And I'm saying that partly based on my experience from 20 years ago of thinking that once the Supreme Court made a revolution, the world would follow with a revolution, and discovering that it wasn't so. The reason is that most people in the United States aren't actually that unhappy about the relationship between religion and government in the schools. Right now, that's not a major hot button issue that people are going to the streets over, which, by the way, it was 30 years ago, and it was 60 years ago, and it was in 1869 through 1876. So it has been, and it can be again. But right now, because of the particular configurations of our politics, it isn't. Happy to talk in the Q&A or speculate in the Q&A about why that's so, but right now it isn't. So most probably, these constitutionally revolutionary decisions aren't going to issue in immediate, overnight, front page transformations. What they are going to do is open the door to a gradual, continuing process in which we have more government funding of religious schools in our country and more manifestations of religion in public schools in our country. And it's going to happen more gently and slowly. And it's also going to happen in very different ways, of course, in different places in the country where the politics and the religion operate in different ways. Now, is all this a good thing or a bad thing? And then I'll be silent. That's actually a hard question. When I started as a baby professor, I had clerked for Justice Souter, as Ronna mentioned, who was the regular dissenter in each of the 5-4 decisions of the era on church and state. And I was very influenced by him. And I felt very strongly that the sky was falling and that the breakdown in the separation of church and state was a disaster. Now, both in the light of the history and of change, I'm maybe a little bit less convinced of that because I can see how the Catholic claim going back to the 19th century to have accommodation in the form of state paying for Catholic education was a plausible claim of a religious minority not to be oppressed by the majority. I can also see the possibility that maybe different places in the United States would take different views about religion in the public schools. I haven't, I would say, been converted entirely to the other side, but I think maybe this is a sign of getting older, that my capacity to become outraged about these issues is a little bit reduced. The other possibility is I'm so outraged about so many other things that are happening in our culture, in our political world, and in the Supreme Court's jurisprudence that I am not feeling right now as though the breakdown of the separation of church and state, revolutionary though it is the worst thing that is happening. In fact, I think it'll be hard to argue that it is the worst thing that is happening right now. So I myself have mellowed from thinking this was the end of the world to thinking this is not how I think the Constitution should be interpreted. I think both Carson against Macon and Kennedy against Bremerton are wrong decisions and bad decisions. Let me be clear about that. I just am not sure they're the worst decisions that the Supreme, in fact, I'm sure they aren't the worst decisions the Supreme Court has made in the course of its present constitutional revolution. But this is what's happening. And the reason there's a constitutional revolution on the Supreme Court right now is just the appointment of 3 new justices by President Trump when he was president. That's got its own complex history. But the takeaway for anyone who cares a lot about these things is elections have consequences, and they have consequences for the Supreme Court in particular. And when you think about the electoral season we're in now, if you care about the Constitution, you should care about showing up and voting for your preferred candidate, whoever that is, because whoever is the next president will also have the opportunity to name new justices who will help specify what the structure of constitutional law will look like for all of your future legal careers. Thank you very much for listening, and I look forward to hearing questions.
We do have just a few minutes for questions. I think what I would ask is that when Professor Feldman calls on you, wait just a minute and we'll bring you a microphone so the question is audible to the group, all right?
Right in the middle with the baseball cap. The drama is killing me.
Sorry, that was dramatic. But one thing that I find very curious about the Carson decision is one of Maine's arguments was that their scheme was just Locke v. Davy, so it was permissible. And while the court rejected that argument, they didn't indicate any negative treatment towards Locke v. Davy. So I was just curious if you had any thoughts on that, or if that showed like maybe some restraint that they're not going to do this full revolution.
Yeah, great question. So Locke v. Davy is an earlier case involving facts very, very similar to the Maine facts. It came out of the state of Washington. The state had something called its Promise Scholarship. And the Promise Scholarship was a scholarship that you could use in whatever major you wanted to in college, except if you were studying, quote unquote, devotional theology. And Joshua Davy was a smart kid from the state of Washington who wanted to be a minister, and he won the Promise Scholarship, and he said, I want to spend my tuition on, I want to spend this money on my tuition in a degree in devotional theology. And the state said no. It went to the US Supreme Court, and Chief Justice Rehnquist, writing for the court at the time, said it's okay for the state to refuse to fund devotional theology, because there are some things that the Establishment Clause would allow the state to do. If the state wanted to, it could fund this degree through a voucher program, that are not required by the Free Exercise Clause. Okay? So that's very similar to the Carson against Macon situation, but with a different outcome. And Chief Justice Rehnquist famously and confusingly said, there is play in the joints between the Establishment Clause and the Free Exercise Clause, meaning there's some things that you could do under the Establishment Clause, but you don't have to do them under the Free Exercise Clause. Now, that decision has been under intense pressure for the last 6 or 7 years. And Chief Justice Roberts, who clerked for Chief Justice Rehnquist and hates to overturn decisions, especially by his old boss, tried to preserve the logic of Locke v. Davy, even as he weakened it, by saying that there was a distinction in some earlier cases, a distinction between the Promise Scholarship, where the discrimination was not based on whether you are religious, but are you using the money for a religious function? Well, he got beaten up by Justice Gorsuch, who said, well, that's the silliest decision I've ever thought of. Is the discrimination against, am I praying because it's a religious act? Or am I praying because I'm a religious person? It can't be that that's the constitutional distinction. And that distinction's been chipped away. And in Carson v. Macon, that distinction is now gone. So what I would say is that Locke v. Davy has now been overturned, but it's just been overturned without saying so, because the Chief Justice doesn't like the court to say it's overturning things. Like in his opinion in Dobbs, where he said, why can't we just say that the law in question is constitutional without saying we're overturning Roe v. Wade? And 4 justices said, because that would be overturning Roe v. Wade, and that's a bad thing. And 4 said that would be, or 3 said that, and the other said that would be overturning Roe v. Wade, and we want to do that. And so there was no one else supporting the Chief Justice's kind of more cautious point of view.
Thank you, Professor Feldman. I kind of had a question that's a bit related to the voucher idea and the broader effects and concerns that may, especially because I know that, it didn't have the revolutionary where immediately there was, but I know that at least, like, I think, for example, here in Ohio, we've heavily expanded vouchers the last several years. And that money has mostly, I think the stat I most recently had, 95% of it's going to religious private schools.
Sure.
And in terms of slow transformational change, do you think that's still a very real possibility around the country when it comes to this? And also the effect that might have along social economic barriers. Because at the same time, Ohio has expanded qualifications to up to 450% of the federal poverty level. And most of the expanded money for the Ed Choice program, I know, is now going to families that were already sending their kids to private schools. It's not actually going to the hands of people that are trying to, like, as a lot of the arguments went for, people who are in poor or worse school districts trying to get a better education for children, when instead it's going to people who already had the means and assets and were affording private schools, and how much of a concern that is.
Yeah, I mean, you're making excellent points, partly because it shows that this is an evolutionary process and it's now a political process. Once the courts get out of the game and say you can do it, it becomes a political fight. And there are different actors. There are the unions on the one side that, of course, for the most part have opposed this. On the other hand are people who want to send their kids to Catholic schools. And one of the really interesting things, in fact, that case that I mentioned earlier in the early aughts actually came out of Cleveland. And there, what was interesting is that the Catholic school districts were not mostly full of Catholic kids. What had happened is that these were urban school districts that had been urban ethnic Catholic school districts. And then, out of demographic change, those neighborhoods had become mostly Black. At the time, not Latino, which was 20 years ago. And as a consequence, because statistically in the United States, most Blacks are Protestant, there weren't a lot of kids who were Catholic. So it wasn't that the Catholic schools were advocating to get voucher programs so that Catholic kids could go to their schools. To the contrary, it was progressively minded Catholic schools that were empty of Catholic kids that wanted to enable local kids to go to those schools who might not be able to afford to go otherwise. And so they were advocating for vouchers. But it's characteristic of our politics that if you're a relatively poor and underprivileged person living in a poor neighborhood, you probably also have less political clout. On the other hand, if people with more means start to see an advantage in voucher programs, that would increase the probability that you would get more such programs adopted. A lot of it goes to how confident are you and how happy are you with the public school to which you send your kids. And if you're not, you're likely to advocate for programs like this. So it's going to be case by case and specific, and the economics come into it alongside the politics. So yeah, I mean, I think those kinds of developments are interesting to watch, and if they succeed in one part of the country, they're likely to be copied in other parts of the country. Again, to be clear, and I try to use that nuance of this example from Cleveland, it's not that simple. I mean, that was a moment when many liberals, my colleague, Professor Martha Minow, mentor to me, also a dean of the law school, a leading liberal person focused on education law, in those years came out in favor of the constitutionality of vouchers, precisely because she was moved by the moral argument that it seems wrong that poorer people don't have school choice and people with more money do have school choice because they can afford to pay for that. Senator Cory Booker, senator from New Jersey, early in his career, came out in favor of school choice, which is a very controversial thing for him to do at the time on very similar grounds. So and he's a very liberal senator. So, the issues are complicated for sure. Okay, this gentleman here, perhaps.
Thank you. Asking you to look in your crystal ball again. Does quality of education play into this at all? And in particular, I am thinking about the relationship between New York City and the Hasidic schools there, where essentially Nothing is taught.
Yeah. So a whole other issue in the religion and constitution in the schools area, one that I haven't addressed at all today, but a really fascinating and new one. I mean, it's not a new issue, but it's been recently discussed in New York, is the question of state-based standards for the basic secular curriculum that must be taught in every school that's going to be accredited, even if it's a fully religious school. Okay? And in New York, as the question suggests, there's been a big conflict over Hasidic schools, so not just all ultra-Orthodox schools, but a specific subset of ultra-Orthodox schools, where some of the schools actually believe that teaching secular studies is morally wrong. And so they minimize the amount of secular education to a point where it falls short of even the bare minimum of math and English that the state requires. And then when the state tries to enforce it, that community makes a religious liberty argument that says we cannot be subject even to these standards. That issue has been extensively litigated at the state level in New York. It will eventually find its way in some form to the Supreme Court, where the Supreme Court will have to answer the question of whether it violates the free exercise of religion to tell parents that they have to send their kid to a school, K through 8th, let's say, that meets minimum standards. And, you know, there is an important case from the 1970s involving high school education, in which the Supreme Court said that the old order Amish cannot be obligated to send their kids to high school, but that case wasn't about K through, I think it was actually K through 9 or 10, maybe K through 9. So that'll be an issue the Supreme Court's going to have to rule on. If I had to look into my crystal ball, I think the Supreme Court might well hold that if a group has a strong religious justification for sending their kids to a school where they are getting an education, but not a secular education sufficient to match the bare standards, that they have a free exercise right to do so. That will be a transformational case too when it comes. I'm not at all convinced that will be the right holding, but I think that is where the doctrine is generally probably heading. I want to thank everybody for being such an amazing audience and taking lunch to talk about constitutional law. Thank you.